Appeals Division 1 is now in session.
Thank you. Be seated. So as a preliminary matter, those of you who feel comfortable doing so, you may remove your masks for the time of this argument. We are here today in case TX20-0003, State ex rel. Brnovich versus Arizona Board of Regents et al. As I'm sure you're all familiar, we record and live stream these arguments. So when you begin, please give your name and the name of your client for the recording. According to our current protocol, and as I'm sure you're aware, you'll be arguing from council table and not from the podium. You may feel free to sit or stand as you wish. Your time limits remain the same and your obligation to maintain your own time remains the same. We do try to make that as hard as possible by keeping the clock on the podium. So feel free to move around as you need to or to ask if you have questions about the time remaining. As I mentioned, you have 20 minutes per side. That is the maximum amount. You're not obligated to use it, but you should feel free to do so. If you'd like to reserve time for rebuttal, that is your obligation to do so. Please do keep in mind we have read the briefing, we've reviewed the record, and we have conferenced this case as of this morning. With that, please feel free to proceed.
Good morning, Your Honors. May it please the Court, my name is Mike Catlett with the Arizona Attorney General's Office, and I represent the state of Arizona ex rel. Mark Brnovich, Attorney General in this matter. My preference would be, if you really don't mind, would be to sit, otherwise I'm likely to be fumbling papers all over. I would like to reserve 5 minutes of my time for rebuttal, but I understand that that's my responsibility. The Arizona Board of Regents has entered into a transaction that both expressly seeks to shelter millions of dollars from the tax rolls and gifts at least $19.5 million to a private business. The Attorney General instituted this action to have the transaction or portion of it declared unlawful on 4 different grounds. The trial court granted dismissal on 3 of those grounds and summary judgment on the 4th. That was reversible error. Although I'm happy to take questions on any of the arguments that we made in our briefing, I'd like to start this morning with the trial court's grant of summary judgment on the Attorney General's public monies claim. Under 35-212, the Attorney General has the express statutory power to bring an action in the name of the state to stop an illegal payment of public monies. The Arizona Supreme Court just last week in Brnovich versus Arizona Board of Regents, what I will probably refer to today as the tuition case, confirmed the Attorney General's statutory authority under 35-212. In early April of 2019...
Counsel, I don't think the Board of Regents is challenging the AG's, and they can correct me if I'm wrong, authority to bring the claim. I think the issue here is the 5-year versus 1-year time limit. And I guess I'd like to draw your attention to the language of 35-212E. Clearly, the legislature knows how to exempt the application of a particular provision because the legislature exempted the notice of claim statute. The legislature did not exempt the immediately preceding 1-year statute of limitations provision. They did, however, explicitly state that an action brought pursuant to this article is subject to Title 12, Chapter 7, Article 2, which includes that 1-year statute of limitations. So can you explain to me how in the language of 35-212, the legislature did not incorporate the 1-year statute of limitations?
Sure, I'd be happy to. And I agree. It's my understanding that the Arizona Board of Regents is not challenging the Attorney General's statutory authority under 35-212, and the trial court in its rulings did not question that authority as well. The reason that the legislature did not expressly call out 12-821, although it did call out 12-821-01, is because 12-821 is not the only statute of limitations that might apply to a public monies claim brought by the Attorney General. So, for example, 12-821 could theoretically apply, although we argue that because of the language that the legislature has now added to 35-212E that it doesn't, but with respect to claims against government officials, prior to 35-212E, 12-821 would be the applicable statutory period. However, public monies claims can also be brought against non-government employees or officials. In that case, there would be no statute of limitations because in 12-510, the Arizona legislature exempted the state from applicable statutory periods or limitations periods. So rather than list out every potential statute of limitations that might apply to a public monies claim by the Attorney General, including 12-821, 12-510, there's potentially other statute of limitations that might apply that I haven't even thought of, or maybe there's limitations periods
But there's
that might
something
be.
particular about 12-820 because this language explicitly incorporates that as part of Title 12, Chapter 7, Article 2, right?
Right, but that particular title and article contains numerous provisions dealing with punitive damages, limitations periods, and so the legislature was making clear that most of those provisions apply, and then it lays out two exceptions. It says we're creating a new limitations period, which is 5 years from the date that the illegal payment is ordered, and we're exempting the Attorney General.
Isn't that not a statute of limitations, but rather a statute of repose? In other words, setting the outer boundary of when a claim can be brought, which is not tied to the accrual date or the discovery date of the payment, just tied to the date of the payment itself. So in other words, we can read both of these together. They don't conflict. We don't have to pick which one trumps. We can say the AG only has up to 5 years to bring this claim regardless of when he discovers that it's accrued, but there is a 1-year limited statute of limitations from that date of accrual.
So a couple of responses to that. One, there's no indication in the statutory language, in the structure of the statute, or in the legislative history that that's what the legislature intended here, was to have a statute of repose overlaid over a statute of limitations. And I would submit that it's an incredibly odd way to do that, to have a statute of repose in one title and a statute of limitations in a completely different title. So you have Title 12. They're not even in the same section, article, or chapter. So
isn't there sense in it, in the fact that if you're looking at a statute of repose, how far are we going to try and unwind a government transaction that somebody just found out about? And the answer is, we'll let you go back 5 years from when you found it. But we're not going to go back further, and you wouldn't put that in a statute of limitations. You would put that in where the action actually lies.
No, I think what would make sense is that the legislature wanted to remove any of the lack of clarity that exists under 12-821-01 and the accrual period and limitations period when it comes to the state seeking to recoup public monies that have been illegally paid, and when the AG, or the Attorney General's office, is doing that. It would make no sense for the legislature to exempt the accrual period that is in 12-821-01 while at the same time attempting to keep 12-821. And the Arizona Board of Regents claims that while the accrual period in 12-821-01B is the accrual period for a notice of claim. It's not the accrual period for the statute of limitations, but that's not what this court has held. In fact, 8 months ago in April, Judge Brown in Humphrey v. State explained that the accrual period in 12-821-01B is a codification of the discovery rule for statute of limitations claims or defenses on claims against government officials. So ask yourself, what's more likely that the Arizona legislature decided to inject a bunch of confusion and muddy the waters here by getting rid of the accrual period that applies to claims by the AG. Sitting here today, I can't tell you when I get a public monies complaint when that claim accrues for purposes of an action that the AG might bring. And we routinely receive public monies complaints, and we're having...
Isn't the answer that the legislature was doing something in addition to the codification that Judge Brown talks about, that the legislature was doing something different here in 35212 in pulling out the notice of claim statute, because the notice of claim provision has a lot of implications. There's the 180-day limitation. There are the affirmative obligations that make sense to place on a private party but don't make sense to place those obligations on the Attorney General. So when the legislature was putting together this illegal payments statute, the goal was to say, okay, we're not going to subject you to this notice of claim statute, but that's the only thing you're not subject to. We have also other statutes of limitations, and we're not exempting the AG from these other provisions.
Right, but I think what at the end of the day, what the legislature was trying to do was to say, we're not going to hold the AG to a one-year period, and we're going to remove any confusion that might exist with respect to the accrual period that is in 12-821-01B. Instead, we're going to make this very clear that the Attorney General has 5 years to bring a claim, regardless of who he brings it against, whether it's a government employee or a private party. In the case of a private party, that actually might benefit them because it creates a new statutory period of 5 years, whereas in the past, the Attorney General could have no limitations period at all. And they said, we're going to make accrual very clear, and the accrual we're going to peg accrual to the order of the illegal payments and not to realization of harm or causation or any of that.
I was just going to say, we're ticking down on time. You're down to about 10 minutes, so unless you want to...
I'm going to beat a dead horse just with one question, which is, I'd like you to go back to Judge Perkins' question on this point. Why can't we harmonize them? There's a 1-year statute of limitations, and there's a 5-year statute of repose. They both stand tall, and we don't get into what the legislature was intending, not intending. Could they have drafted it better? But they both stand. Why can't we use that harmonization rule?
Because I actually think the rules of statutory construction in this case dictate that 35212E prevails over 12-821. And we talk about those. There's 3 rules in particular that we talk about in our briefing. There's the rule that the more detailed statutory limitations period prevails over a broader limitations period. Clearly, 35212E is more narrow than 12-821. The more recent enactment.
We'll have to consult the briefs for those 3 reasons, but I think that's the answer.
That's the answer.
Let's assume now, because we need to get to some of these other issues under the summary judgment ruling, let's assume the 1-year statute of limitations applies. So talk to me about the relating back issue under Rule 15C.
Sure. So under Rule 15C, so long as the transaction, occurrence, or event underlying the amended complaint is the same as the transaction, occurrence, or event underlying the original complaint, then the claims in the amended complaint relate back. Here,
So
Counsel,
I could, sorry, you go.
Wouldn't there be a substantial amount of discovery involved on the gift clause claim on count 4 as compared to counts 1 through 3? Correct me if I'm wrong, but aren't counts 1 through 3 more of a legal question, whereas count 4 would require getting down into some factual analysis?
I don't think so, Your Honor. I think that the claims, counts 1 through 3 in the original complaint are going to require similar discovery as to what the gift clause claim. In other words, we're still going to want all the transactional documents. We're still going to want communications between Omni and ABOR that were made in connection with the transaction.
Whether the property is subject to taxation?
Correct. Whether the intent of this transaction is to evade property taxes, whether ABOR had the authority to enter into this transaction, and I'm not aware either that under Arizona law that the amount of discovery that is going to occur with respect to new claims versus the old claims is relevant to relation back. I mean, I know that under the Ninth Circuit they've mentioned this same evidence test. My argument is...
I think the issue that Judge Brown is getting at is that tells you how similar, how much overlap there is between the claims, how distinct the factual bases are, and that is a concern for this court. Is this based on the same facts? The AG's additional 17 pages of facts brought with the amended complaint suggests that there's possibly a different universe of facts, or at least there are additional facts, a lot of them, under count 4. So I think that's the concern. I mean, the gift clause cases that we've seen involve expert testimony into the financial ramifications for the city We've recently had a case out of Glendale on this. There is substantial discovery that is required and different elements of proof on these claims. So I guess that's our concern, is these seem like sort of two different suits merged together by virtue of this amended complaint.
Right, and our position is they're not two different suits. Rule 15 says if the transaction is the same, then the claims relate back. Here, in the original complaint, the transaction that was challenged was this transaction between Omni and the Arizona Board of Regents. The transaction that is challenged in the amended complaint is that same transaction. ABOR wants to characterize the claims in the original complaint as tax claims, but they were not all tax claims. We challenged the transaction in the original complaint under 151625. That is a direct challenge that really doesn't have much to do with property taxes. It says that ABOR doesn't have the statutory authority to hold title for the sole benefit of a private party. And we challenged the constitutionality of the transaction under the evasion
But all of
provision.
those claims relate to the lease, right? The nature of the lease, the nature of the property, the ability to collect taxes, the rent payments, whereas the gift clause claim relates to a whole separate portion of this agreement in terms of the $19 million, whatever it was, payment, right? That payment wasn't really a part of the counts 1 through 3, was it?
Well, it wasn't. That payment is part of the transaction, and that the transaction was what was being challenged in the original complaint. The additional argument that we make is that the property tax claims relate directly. They're interrelated with the gift clause claim. So if we prevail on our argument that this transaction is not tax exempt, then it reduces the consideration that the Arizona Board of Regents receives under this transaction and has a direct impact on our gift clause claim. So not only are they interrelated, but they're mathematically dependent. And therefore, it's the same transaction that's being challenged. I understand there's an additional cause of action, but the Arizona, as we point out in our briefs, the Arizona courts have never adopted a same evidence test. But even if you want to, the evidence here is the same. There may be some additional evidence that would be brought in because of the gift clause claim, but the underlying evidence that we would present with respect to the gift clause claim would be the same evidence that we present with respect to the original 3 claims.
With some of your final 3 minutes, 48, let's talk about the dismissals. With regard to count 1, if the property is not subject to taxation, what tax law is the AG enforcing?
The AG is enforcing the provision in the Arizona Constitution that prohibits parties from entering into conveyances to evade taxation.
Is a lease a conveyance?
Yes, yes, clearly a lease is a conveyance, and we cite a case in our opening brief saying that the lease is a conveyance. The lease is a conveyance, and the Omni is making improvements to the property. Those improvements are eventually being titled in the name of the Arizona Board of Regents, and those improvements would ordinarily be taxed. Their argument is, well, these have always been tax exempt, and so they're going to remain tax exempt, so we're not evading taxes. Our argument, and we pled this, and it should be assumed as true, our argument is this, for all intents and purposes, this is a sale of this property to Omni. The only reason that it's being labeled as a lease is to avoid taxation, and that is clearly a violation of the evasion clause in the Arizona Constitution. Now, with respect to 1625, we have the same similar argument. We alleged that the proceeds of this sale are not intended to benefit the state or the Arizona Board of Regents, and that allegation needs to be taken as true. At the very least, we're entitled to discovery as to what the nature of the proceeds from this transaction are going to be and who are they going to benefit. And then finally, we make the argument that for purposes of tax exemption, the Arizona Board is not the state of Arizona in Article 9, Section 2, Subsection 1. that provision mentions 4 political entities: the federal government, the state government, counties, and municipalities. This court held in the Pima County Industrial Authority case that if an entity has the authority to issue bonds, that it is a political subdivision and it is not the state.
What about the Kaman Aerospace Corp. Decision in which this court said that the Board of Regents is a state agency?
Well, you can be a state agency and still not be the state. You can be a state agency and be a public.
Can a state agency be a franchise?
Yes. A state
What
agency
is the best case that tells me a state agency can be a franchise? What is your best franchise case, I guess?
So we cite a series of cases in our reply brief where parties were able to bring quo warranto claims to challenge actions that were made by governmental entities, including counties and commissions and boards. And so those series of cases that we cite in our reply brief, I think, fully support and establish that entities like the Arizona Board of Regents is a franchise. If it's not a franchise, it's a public office, and both are covered in the Quo Warranto Statute. If there are no further questions, I'd like to reserve the balance of my time.
Yes, and in recognition of recent updates to the law and the broad nature of this case, with the agreement of the panel, I'd like to add 2.5 minutes for the rebuttal time, and we'll add likewise 2.5 minutes to the appellee's time. So we'll give our trustee law clerks just a moment to adjust the clocks. I think we're set.
Thank you, Your Honors. My name is Joel Nomkin. I represent the Arizona Board of Regents and John Greer, and with me are Austin Yost and Brett Johnson. So 2 points decide this appeal. The Attorney General's tax claims fail as a matter of law because he doesn't have authority to bring them, and his gift clause claim fails because it was brought beyond the 1-year statute of limitations, which controls here. I'd like to pick up where we left off and talk about the tax claims first and explain why the Attorney General doesn't have authority to bring them. So let's first turn to count 1 of his complaint, which says that the Omni deal supposedly is subject to taxation. The Attorney General relies for that claim exclusively on the tax enforcement statute. Now, that statute doesn't apply for 2 reasons. It can't give the Attorney General authority for 2 reasons. First, the statute doesn't give the Attorney General the authority to bring a tax enforcement action when he hasn't been requested to do so by the Department of Revenue. That's clear from 42-11052A, which is the statute that specifically deals with lawsuits to enforce the property tax laws.
Doesn't this tax statute include the prosecute language?
It does.
The court upstairs gave us some new information about?
It does, Your Honor, but it's important, as the court upstairs said, we have to look at the statute. That statute, which you're referring to, says, and that's 1004E. We have a lot of numbers here. Yeah. It says that the Attorney General shall prosecute actions necessary to enforce Title 42. We learned from the Supreme Court's decision that is a duty statute, not an authority statute. And so when is it necessary for the Attorney General to enforce the tax statutes? Well, we know from 11052A2 that in the legislature's view, it's when the Department of Revenue requests him to do so. In fact, Title 42 has 12 separate provisions that deal with the Attorney General's authority to bring a lawsuit for enforcement. Each one of them is conditioned on the request of the Department of Revenue. And so I think that clearly evidences the legislature's expectation that it's the Department of Revenue that's going to decide when to bring a lawsuit, and that the Attorney General's job is to represent the department. In fact, we're not aware of any case, and the Attorney General hasn't cited any, where he has brought a lawsuit to enforce the property tax laws without a request of the Department of Revenue. And there's a second reason why that statute, the Tax Enforcement Act, doesn't apply to count 1, and that's the reason that Your Honors talked about earlier, which is that there is no tax to enforce. And that's what the tax court ruled as well. The Constitution has a categorical rule in Article 9, Section 2(1). It exempts from taxation all state property. And this court has consistently held that the board's property is covered by that provision.
But what about subsection 12? If it's the property has been conveyed to evade taxation?
So, Your Honor, I think you can't convey property to evade taxation if it's not subject to taxation in the first place. As the tax court said.
Well, you could, hear me out here, you could certainly convey it through a lease, a 99-year lease, and you could say, well, look, in order to avoid taxation here, I'm going to convey this lease to you. You can have this for 99 years. How is that not? A conveyance is a lease. A lease is obvious a conveyance.
Oh, sure. The point
is to avoid somebody. Now, it doesn't say who's avoiding taxation. The
Well,
lessor, the lessee?
And Your Honor, the point is that the board owns the property now. It will continue to own the property, have title to the property throughout the term of the lease. And this is exactly, as the tax court said, this is exactly like the Clark and Fox Riverside Theater cases. And Clark has some pretty interesting language saying, the courts have long since passed the Rubicon of looking to see what the use of public property is going to be. It doesn't matter if it's going to be put to a commercial use or not, as long as the public entity that's subject to the tax exemption under the Constitution owns the property, it remains tax exempt. And that's what this court said in the city of Tempe.
So are you saying that the Clark case forecloses the bare title argument?
I think so. It's the Clark case, if you want to look at the Fox Riverside Theater case, where the city of Phoenix entered into a long-term lease of its property to have a movie theater built. And of course, the movie theater was a commercial purpose. The theater owner gained all the economic advantages of it, but the improvements were owned by the city and therefore subject to the tax exemption. There's nothing unusual about that.
If we were to rule otherwise, would it subject every single lease that the state, any state entity enters into? For example, the law school enters a lease for a restaurant on the first floor, and all the different leases that are out there with commercial vendors, would all of those be subject to a tax?
I think that's the problem. And what we have is the Constitution set forth a categorical rule. State property is exempt from taxation. And there's no case that suggests that the board's property isn't within that exemption. And again, also, there's not been a request by the Department of Revenue to bring a lawsuit. Let me turn to the counts 2 and 3 of the tax claims. Now, those counts rely on the Quo Warranto Statute for authority. But the Quo Warranto Statute, and he's relying on the statute to say that the board is exceeding its leasing authority. The Quo Warranto Statute, the purpose of the Quo Warranto Statute is to see, does a person have the right to hold or exercise an office?
So what you're saying is it doesn't matter whether, we don't necessarily have to reach the question of whether or not ABOR is a franchise or public officer or official within the first part of this analysis, because the way this statute is used is not for these purposes.
That's exactly right, Your Honor. It is not used as the Attorney General is trying to use it here to see how a public officer exercises their authority and implements their authority. The purpose is to see whether or not the person claiming the office has a right to hold or exercise it in the first place. In fact, if you were to conclude otherwise, then essentially what you would be doing is saying you would be turning the Quo Warranto writ into a license for the Attorney General to sue any state official or agency because he disagrees with the way they're carrying out their authority. You'd open up the Attorney General to the same kind of common law authority, unmoored to any specific statutory authority that this court, the Supreme Court, and the Supreme Court just last week said that the Attorney General doesn't have. In supplemental briefing, the Attorney General relies on 35212 as well to support the tax claims. But again, last week's decision by the Supreme Court tells us that that is just not possible. If you look at paragraph 22 of the Supreme Court's decision, it says that a claim can be authorized by 35212 only when it is aimed at aiding the Attorney General in preventing or recovering illegal payments. The Attorney General never suggested below in the complaint or in his papers that the tax claims are independently authorized by 35212, and those tax claims don't even mention the board's payment to Omni, let alone are they aimed at stopping and preventing those unlawful payments. In fact, if you read the Attorney General's brief, he said that at the time he filed the tax claims, he didn't even know about the payments that the board was supposed to make. So the question isn't, as the Attorney General would pose, whether or not success on the tax claims might have some indirect collateral benefit for the gift cause claim. It has to stand alone. Looking at the tax claim standing alone, is it aimed at preventing an unlawful payment? The answer just has to be no. So I'll turn next to the count 4, which is the gift clause claim. And I think, as your honors have already discussed probably enough, more than you'd want to, the 1-year statute of limitations applies in categorical language. That's 12.821. All actions against any public entity shall be brought within 1 year.
What about the AG's argument that 35212 is a more specific, more recent statute and brings out this new, in this specific area, 5-year limitations period?
I'll take that it's a specific statute, but the first sentence of 35212E says that an action brought pursuant to this article is subject to Title 12, Chapter 7, Article 2, and Article 2 includes the 1-year statute of limitations. And there is, as the court has noted, there is no inconsistency in having both a statute of repose, which is what the 5-year rule is. It's not tied, 5-year rule isn't tied to when the claim accrued, when the Attorney General knew or should have known. It's a automatic rule that says whether you knew it or not, 5 years after the illegal payment was ordered, that's all you got.
Why can't we accept the AG's argument that the language, the action must be brought within 5 years, is an implicit rejection of the 1-year statute of limitations? So it's subject to that title, except the limitations.
I don't see how you could read it that way, Your Honor, if for 2 reasons. One, that is the language, that's the second sentence of subsection E, is the classic language of a statute of repose. So there's no reason to assume that the legislature was attempting to nullify a statute of limitations with a statute that has a different purpose, a statute of repose. And second, you've got the plain language of the statute to deal with, which is the plain language of 821, all. It can't be, you can't come up with a more comprehensive word than all. And you have the first sentence of the statute that the Attorney General relies on, which says we incorporate the 1-year
So
statute.
refresh my memory from the briefing.
Yes,
It's been
please.
a lot of briefs for today.
Yes.
How do you read both of these statutes in harmony? How do they work as a practical matter together?
So let me use another example. If you take a look at the securities fraud statutes, for example, and Title 44, they include both a statute of repose and a statute of limitations. That's in 44 2004C. It's not at all uncommon to have, they serve different functions. One says, okay, we really want the plaintiff to move quickly, and so you've got to bring your action when you knew or should have known of it.
And here
It's 1 year.
1 year.
The 5-year rule says, look, whether you knew it or not, there's got to be some endpoint to when you're going to be able to sue public agency or public official. And we're going to say it's 5 years, whether you knew it or not. We just have to have more certainty in life to allow claims to continue to grow, especially when you're challenging government conduct. I'll turn to the relation back argument next. So let me set the stage, if you don't mind, before getting into the law on that argument about what the Attorney General's said and did in this case. So when he filed the original complaint, he acknowledged it was a tax case through and through. That's why he filed it in the tax court. And his complaint said that venue was proper there because the suit involves, I'm going to quote, the suit involves the imposition, assessment, or collection of a tax, including questions of law and fact relating to the appropriate tax treatment for certain property. And that's why he named the county assessor and the treasurer as relief defendants so that they could be forced to collect and impose the tax. And look at the Attorney General's reply brief in this court, first page. He says, quote, counts 1 through 3 challenge the transaction based on its unlawful property tax aspects, end quote. In contrast, he says, quote, count 4 challenges the transaction based on illegal payments of public monies. And that's right. And that's why the tax court held there is no way to relate the gift clause claim back to the original claim.
Oh, there, Rule 15C does use the language transaction.
It does.
These are perhaps different parts of the transaction, but they are part of a transaction. So how do we get around that language in Rule 15?
You don't need to get around it. Transaction is a term of art. It's not simply a matter of whether or not the claims might have to deal with the same deal. Claims arise out of the same transaction as a matter of law, this is legal interpretation, if they share a common core of operative facts. The Wright-Miller treatise is cited by this court, by the Supreme Court frequently as a guide, and as it said, under the same rule, the search under Rule 15C is for a common core of operative facts in the two pleadings. So to satisfy the common core test, the plaintiff has to rely on the same evidence and facts to prove each claim. Our brief cites federal appellate decisions from around the country that stand for that proposition and that refuse to allow relation back when the amended complaint relies on new facts and evidence. They recognize that a simple overlap, like what the Attorney General is relying here, just isn't enough to give the defendant fair notice of the amended complaint. Those decisions, the Supreme Court tells us, are instructive and persuasive. They're perfectly consistent with Arizona law. I know the Attorney General relies heavily on the Marshall case from the Supreme Court. That case is perfectly consistent. While it says, of course, that a simple change in legal theory doesn't preclude relation back, it goes on to say, if the factual situation upon which the action depends, remains the same and has been brought to the defendant's attention by the original pleading. And I just completely fouled that up. So let me try it again. It says that relation back will work only if the factual situation upon which the action depends remains the same and has been brought to the defendant's attention.
Let me ask you this, because you've used two terms, common core,
Yeah.
and then there's a simple overlap you've said will not suffice. But at some point, the overlap becomes more than an overlap and it becomes a common core. I mean, that's the sliding scale here.
Sure.
So why is this case a simple overlap as opposed to the common core?
Well,
what makes that different?
So I think let's take a look at the gift clause claim. So it's based, according to the Attorney General, on payments of public monies that shouldn't have been paid, the $19.5 million that the board was obligated to pay up to for the conference center. Okay, what in the original complaint had to do with the $19.5 million? Nothing. There was nothing about any payments that were going to be made by the board that were referenced in the original complaint. Look at the merits, the elements that you have to prove to establish a gift clause claim. You have to show that the consideration that the board would receive for its payments was grossly disproportionate. Okay, so what does the original complaint say about the consideration that the board would receive in the Omni deal? Nothing, not a thing. Those facts are only in the amended complaint over the course of 17 new pages of facts and attachments. If you look at, for example, paragraphs 81 through 93 of the amended complaint, they add allegations about the supposedly lopsided terms of the deal, the alleged value of the consideration that was being exchanged, the fair market value of the land and other transactions. None of that is in the original complaint. Or look at paragraphs 100 and 105 of the amended complaint, which detail what the university is getting for funding the conference center and the parking facility. Again, nothing in the original complaint about that. So the original complaint simply did not put the board on notice, on fair notice, that they would end up fighting a gift clause claim. The last issue on the statute of limitations, of course, is the accrual question. Did the Attorney General know more than a year before he filed his complaint of his claim and injury? And you don't need to look further than the Attorney General's 30B6 deposition to answer that question. He admitted in the 30B6 deposition that he knew that the Omni deal required the board, that the Omni deal required Omni to pay rent in lieu of property taxes. And he knew, and this is more than 15 months before he filed his complaint, he knew about the Omni deal and the in lieu structure. And more than 15 months before he filed his complaint, he admitted that he knew that in his view, that in lieu payment structure violated the gift clause. That is certainly enough facts to start the statute of limitations running and to impose at least an inquiry investigation to find out further facts. Now, the Attorney General says that he didn't actually know of the $19.5 million payment and other terms of the deal until after he filed the original complaint. But even if he didn't actually know them, he certainly reasonably should have known them. Again, he admitted that he knew the basic facts that constituted the violation, that this deal involved an in lieu payment structure. And he admitted in his deposition that the terms of the deal, like the $19.5 million payment, were not only that they were publicly disclosed, and I'm quoting his words, and knowable by people in the Attorney General's office. That's undisputed statement of facts, paragraph 98. And publicly disclosed and knowable is really an understatement. Our statement of facts is just riddled with news articles, editorials, minutes of public board meetings and legislative meetings, meetings that were live streamed, that report.
Counsel, I'm sorry, you have 1 minute left, so I want to get to just two quick
Sure.
other questions. First, on the dismissal of the individual career from the case, procedurally, if we were to affirm the summary judgment ruling, then no matter what we did on the dismissals, the question as to the individual career would be moot. Is that correct?
I would hope
Because that
true.
claim is gone.
I would hope so, Your Honor.
I'll give the AG a chance to.
If the Attorney General would agree that that claim is gone, that the only claim, again, if you were to hold that the gift clause claim is gone, would that then moot the issues as to career? I would hope so, and if the Attorney General would so stipulate. Of course, there are other reasons why Mr. Creer should be named.
Setting aside the merits of the dismissal appeal. And then just very quickly on the attorney's fees claim, it's hard to deny this is a fairly substantial, maybe not unprecedented, but somewhat close to it in terms of what we see here, award. So I guess I just want to give you a moment to respond very briefly to the AG's challenge of the amount of the award.
Well, I think the Supreme Court decision that we cited in a notice of supplemental authority states the groundwork. This is in the state of Arizona versus city of Phoenix case. The Attorney General has an obligation if he's going to challenge either the reasonableness of the rates or the amount of time. And that's, he's got to come forward and say, okay, here's the evidence that shows that your rates are too high, or here's the reasons why you're spending way too much time on this matter. He didn't come close to doing that, and he doesn't come close to doing that on this appeal. He has a burden that he's got to meet. We have set forth with declarations and affidavit, this is the time we spent. In fact, it was discounted because our time was discounted because this case was so substantial and had required so much background work in order to bring.
Okay, thank you, counsel.
Thank you.
Real quickly, the original complaint did challenge the consideration that the Arizona Board of Regents is receiving under this deal. It challenged the tax exemption of the property to the extent that this property is not tax exempt, that has a direct bearing on the payments in lieu of taxes that the board thinks it's going to receive in the future from Omni. There's a dollar-for-dollar reduction, and so there's substantial overlap between the original complaint, the amended complaint, and between the tax exemption claims and the 35212 public monies claims. So that ties into why the AG also has statutory authority to bring the tax exemption claims, because they have a direct impact and they aid the public monies claim. And just last week, the Arizona Supreme Court said it didn't question Woods v. Block, it didn't question fund manager. It said 35212 gives the Attorney General the statutory authority to bring any claim that aids the Attorney General in recovering the illegal payment of public monies. Even if 12-82101B applies, accrual precludes summary judgment. There was a clear allegation in our summary judgment briefing that the Attorney General didn't know, didn't realize that there was a payment of public monies involved in this transaction until November of 2018. There's been no evidence submitted to contradict that statement. The board relies instead on press clippings and internal memos at the Attorney General's office about different transactions that the board had entered into in the past involving payments in lieu of taxes. Those payments are from Omni to the board. Those are not necessarily public monies that the board is paying, so it doesn't necessarily trigger the Attorney General's statutory authority under 35212. What triggers that authority is the payment of money from the board to Omni, and the Attorney General didn't realize that that was occurring until November of 2018. The Clark and Fox cases that counsel mentions predates the evasion clause, which was put into the Arizona Constitution on its own as a separate provision in 1996. So those cases have no impact whatsoever on the evasion analysis. Or to your question, Judge Goss, ordinarily, educational property will still be exempt. We're not here saying that most of what the board holds isn't going to be tax exempt under Section 2.2. It just needs to be used for an educational purpose, and it needs to not be held or used for profit. The vast majority of what the Arizona Board of Regents holds in terms of property will fall within that provision. The reason why this is all new is because the board just recently, in the last 5 to 10 years, decided to embark on these new ventures where it holds title for the benefit of private property owners.
Your time is running, but I still would like you to answer the same two questions that we ended with over here. So the first is with regard to the individual claim against Creer. Just for sake of this question, let's assume that this court affirms the summary judgment ruling, so count 4 is gone. Regardless of what we choose to do with the counts 1 through 3 on the dismissal rulings, the claim against we don't need to reach the dismissal as to Mr. Creer because that is now moot by virtue of affirming the summary judgment ruling. Would you agree with that?
Correct.
Okay. Attorney's fees, 20 seconds. What is your argument on attorney's fees?
In 20 seconds, you had motion to dismiss briefing, you had discovery that was limited to the issue of statutes of limitations, and you had summary judgment briefing. It's unreasonable to take the position that that justifies almost $1 million in fees and costs.
Let me be more specific. Where in the record did you make an objection to the rates or to specific time entries?
If we were required to go through item by item and say this is unreasonable because it's an hour and a half instead of an hour, we did not do that in response to the motion for attorney's fees.
Okay. Thank you, counsel, for the briefing, the argument. We will take the matter under advisement, issue a decision in due course. Court stands in recess.